Right, there we go. We've got it all going. The title was never supposed to be that mysterious. Simon just said, oh, can I put something into his sort of paper system to put my name down that I'll be doing a presentation. I didn't know what I was going to be talking about. Can you talk about data protection? And can you talk about the general conditions? And can you make it funny? And then he put me on at 4 o'clock, which in Simwood time's about 4:30, towards the end of the first day. But let's see where we go. Of course, the world of private browsing is going to be changing soon anyway. If you haven't noticed already, new law coming in should be around April time. Age verification, probably ID required before anyone can get to a porn site. The internet world is going to look quite interesting come April. Who are we? I'm Neil. I'm a lawyer, I'm afraid. I run a law firm called Decoded Legal. We do a range of tech, telecoms, internet, geeky stuff. You can get hold of us at decoded.legal, or for those of you who are a bit more geekily inclined, you can reach us directly over SIP. And for those who want it, you can also find us on the darknet, but you'll never remember the URL, so don't worry about it. Today, data protection. Everyone loves data protection. We'll talk a bit about investigatory powers and the changes that happened earlier this week that may affect some of you. Ofcom's changes to the general conditions that kicked in October, and we'll lastly talk really briefly about the European Electronic Communications Code and what that's likely to mean over the next couple of years. I don't know if you're doing questions as you go or questions at the end. Whatever works for you, shout them out, and I will try and keep us to time anyway. I've been told I've got half an hour. Can I please cover all these? So buckle in, this is going to be a pretty fast ride. 3 things. Data protection. Who's heard of GDPR? Yeah, you survived. That's everyone talking last year about how terrible it's going to be. Actually, the world hasn't looked that bad. So, deep breath to start with, you survived. You haven't had any of those massive fines that were going to drive you out of business. Unless you Google. Google has been hit by a pretty big fine. Probably nowhere near enough to cause Google too much of a problem, but generally that idea that everyone's going to be fined out of existence come June or July last year hasn't happened. Yeah.
I did read that it paid more in fines
than it does in taxes. Yes. Which I don't know whether that means either the data protection regulator is doing really well or HMRC is doing really poorly. But yeah, or indeed a bit of both. Yeah, Google paying quite a lot in fines, and Facebook's having some problems in Germany. But overall, the picture hasn't been quite as bleak as a lot of people were predicting. Now's as good a time as any to perhaps take a look back. Yeah, I'll try that in English. Take a step back, look at what you've done, revisit some of the guidance on the Information Commissioner's website. Just step through it and see how you're lining up. See what you've done well, see what bits you've got gaps, see what you can still try and fix. Information Commissioner's Office website has actually got some really useful resources on it. Lots of tables, lots of checklists. Take a look through, see where you've gone, but so far, no massive fines, at least in the UK, for anyone to worry about. Yeah. Brexit. Not ideal from a data protection point of view. However, you might still be subject to the GDPR anyway, particularly those of you with international customers. If you, as a company, you're established in the European Union, you have sort of stable arrangements for trading in the EU. If you actively sell to people in the EU, you're going to be subject to the GDPR anyway. Or if you monitor the behaviour of people in the EU. I've included that there for completeness, probably doesn't apply to a lot of you, may well apply to people who have like buttons that they embed on websites all over and then can track behaviour on people on other websites. But you could be subject to the GDPR anyway. Even if you're not, even if you don't do any of those things or you're not established in the EU, the UK, in an attempt to break away from that horrible European Union, has basically taken the GDPR and put it into UK law anyway. So if you haven't seen it, Data Protection Act 2018. Pick a day when you're really bored, it's 812 pages long. So the gist of it though carry on complying with the GDPR. What you've been doing so far is still great. Carry on doing it. If you carry on doing what you've done so far, that will still put you in good stead for the new regime. But it's not all that good. The UK becomes a third country. And for those of you familiar with Ender's Game, a third was actually, thirds got picked on quite a lot, but one turned out to be pretty good and saved the world. From a data protection point of view, there's a cup of tea coming for someone. There we go. From a data protection point of view, being a third is not so good. There's an assumption that if you're a third country, your laws are not good enough. You do not look after people's privacy. On exit day, the UK, in the absence of an agreement that I don't think is forthcoming, will be a third country. Our laws will have gone from fine the day before to inadequate the day after. There are different ways that, even if your laws aren't deemed good enough, you can still find a way through the maze that I'll talk about. One of them is an adequacy decision, and that says, well, we know you're not in the European Union, but we've investigated and we've found your laws to be good enough. The second is putting some safeguards in place, and that's predominantly contracts. Or the third is looking for a derogation, an exemption. We'll leave derogations aside because they basically never apply, and when they do, they're so limited in scope, they're not that helpful. So, an adequacy decision. Will the UK's data protection laws be found to be adequate? Well, we won't have one on exit day. That's for sure. They take time. Japan has just been found to have adequate laws, and that took many months of investigating, so we know we won't have one come the end of March. Some people say that actually we will never have one, and point to things like our investigatory powers regime. I'm sceptical, largely because all the countries that are deemed adequate have very similar regimes that may just not be as transparent as ours, but some question if we'll ever have one. So for now,
2 years could have been used for this purpose.
I get the feeling, so I get a feed of sort of changes to legislation coming through in my inbox, and it used to be you sort of got 4 or 5 things come through a day. Now, every quarter of an hour when the feed refreshes, I just get a list of EU regulations that are now being adopted into English law or something like that. So they're trying hard. It just looks like an awful lot of things that we're trying to escape from coming into our own laws. But an adequacy decision, not going to help us immediately. Maybe in the longer term, maybe we'll be brought back into the fold. So the only real choice is appropriate safeguards. And some of you may have come across these standard clauses before. This is a contract that if you sign up to it with someone based in the EU, or in the EEA perhaps, you're fine. You're deemed, you've put a nice protective wrapper around the data, that's fine. It looks like a contractual wrapper, but that's fine. And they come in 2 different flavours. One is if you're trying to move data around from one person in control to another person in control. The other, if you're appointing a processor. Why do you care about this? You care if you're a UK entity, if you're established in the UK, and you're receiving data from a company, a controller, or a processor in the EEA. If you do, and you don't have one of those contracts, A, they're breaking the law, but you're also breaking the law as well. So expect, if you have relationships with companies in the EU transferring data to you, personal data to you, they will come and ask you to sign up to these model clauses. If you are transferring personal data outside the EEA to comply with the UK's GDPR, you will need to be putting these contracts in place with your overseas partners. Fortunately, go onto the ICA's website, and they've got a really nice click-through tool that can help you work out what do you need, when do you need to put it, which version of the contracts do you need, and it even generates you sort of a completed version that you tick some boxes and it goes through. So life doesn't need to be too difficult, just add it to your list of things to do. But what about the USA? They have Privacy Shield. But we have a problem. Privacy Shield is an agreement between the EU and the US. And you can see where we're going here. If we leave the EU, we can no longer rely on Privacy Shield to protect transfers of data going to the USA. So, third aspect of your planning, have a look at your data flows, work out where, if at all, you're transferring personal data to the USA. Okay, step one. Step two, look at what basis you're relying on. And if you're relying on Privacy Shield, those are the transfers that you need to be thinking about. And where you are relying on Privacy Shield, take action. Now, the UK government has said that as long as the US company expressly updates its public commitment to say, we will apply the Privacy Shield principles to data from the UK, that'll be fine. Now, the government said that that will be fine, but they haven't actually put through the legislation that means that it will in fact be fine. No, it's okay, they've got like a month and a bit. I'm sure it will happen. But just in case it doesn't, be prepared to put in place model clauses as well. So if you can't persuade your US supplier to update their commitment, or if the legislation doesn't end up happening that this is going to be acceptable, go back to the ICO's website, find those model clauses that apply to what you're doing, put them in place with your US company. Pick the right ones. If you're giving them the data for their own purposes to use how they want, you want controller to controller. If you're giving them the data and they're doing something on your behalf, you want controller processor clauses. But start thinking about that now, because you will need to comply with data protection law to have these in place by the end of March. Okay, so if you can't do any of those, are they the right people still to be trading with? Now that's a really difficult call, because you have not got long to make a decision that could be really quite important to your business. So the sooner you think about it, the better. But you've basically got three things from a data protection point of view. Revisit your existing preparations. If you've done well in terms of the GDPR so far, you will carry on doing well under the new framework, but now's a pretty good time. Benchmark, see what you're doing, fix any bits that aren't so great. Identify transfers coming from the European Economic Area to you in the UK. You'll probably need to put in place model clauses for those. Identify transfers from the UK going out to the USA. Get them to update their Privacy Shield commitment if they're already self-certified to Privacy Shield. If they're not, model clauses again. But whatever, put the right mechanisms in place. So I told you this would be exciting. Okay, that was the data protection bit. Investigatory powers. Investigatory Powers Act 2016 still gradually coming into force. Okay, retention notices. God's sake, don't put your hand up if you have one. You have duties, if you have a data retention notice, around the security and the resiliency of your retention environment. Only point to make on this, since the law hasn't fundamentally changed, is that the Information Commissioner's Office has now started auditing providers with retention notices. If you have one, then you may have heard that the ICO is coming to have a chat with you, 2 or 3 day audit typically, and looking through very similar things to what they would have looked at under the old regime. Checks, controls, balances to ensure that you're looking after the data, you're not keeping data for longer than it's needed, you're destroying it. Fundamentally, the things that it's interested in. If you don't have a retention notice, nothing to be thinking, nothing to be worrying about here. On the flip side of things, is people coming to you asking for communications data. Not the content of a communication, but data about communications. And even if you don't have a retention notice, as telecoms operators, you are eligible, you're mandated, to respond to requests that come from law enforcement under the Investigatory Powers Act. That all changed as of this week. So before February the 5th, people would have come to you under Regulation of Investigatory Powers Act 2000, RIPA. Some of you may have seen sort of Section 22 notices coming in asking for data about subscribers or about subscribers' use of your services. As of February this week, authorities are entitled to come either under RIPA or under the new regime. So things are going to be complicated pretty much for the end of the year. The approach that the Home Office is taking is a phased transition. So gradually over the course of the year, you'll see different authorities move from RIPA across to the IPA to acquire communications data. They can use either during 2019. Either is legally valid. Probably from the end of the year onwards, RIPA will fall away and it will just be the IP Act for communications data. I say just the IP Act. Actually, there are a whole load of powers that people can use to acquire comms data. Those are due to be stripped down over the course of the year as well. But for now, potentially requests under both. If you get one of these notices, you have a duty to assist. You're only required to do what is reasonably practicable, but if you can do something, if it's reasonable for you to do it, you're required to do it. It is enforceable by an injunction if you don't do it. One area where things look a bit different is that if you were to receive a notice under RIPA that said, right, we require you to hand over comms data on a forward-looking basis, that was limited to 30 days. A RIPA notice expired after 30 days automatically. IP Act comms data notices do not expire. They don't have an end date on them. They can have an end date on them, but they don't automatically expire. They last until they are cancelled. RIPA notices 1 month only, so check carefully what framework people are coming to you under to make sure that you're not either over-disclosing or else under-disclosing and so failing to meet your obligations under the IP Act. Notices themselves look pretty similar. They will tell you who's giving it, what you need to do, how quickly you need to do it, bearing in mind you still only have to do what's reasonably practicable, and how technically to get the data to them. You should also have contact details for getting in touch with people to discuss the notice if you need to. One change. Before, under RIPA, you were not compelled to provide information about your service architecture. That fell outside the scope. That has now changed, and an IP Act notice can expressly include an obligation to provide information, architectural information. So examples have been given, so for mobile providers, cell tower information, Wi-Fi hotspot providers, the location of Wi-Fi hotspots. Not sure how that would apply in a sort of context of a SIP environment. Not sure, but you could be asked for information about your systems rather than just about individuals and their usage. So expect that that might come. Second change is that unauthorised disclosure of a comms data notice or authorisation is a criminal offence, up to 2 years in prison or a fine.
So we've only had one request for anything, and that was a copper who strangely went to the least likely director to have that information in the company at 7 o'clock in the morning, asking for details of who owns this IP address, because apparently there was a girl going to commit suicide.
Okay.
So I then got phoned, and we chose to give that information quickly, but it wasn't an official notice. It was him rocking up at the co-director's house and saying, we need this information of who this subscriber belongs to. Are you saying now that us disclosing that without it being an official request would be a criminal offence, or is that not?
No, I'm not. What I'm saying is the disclosure of the existence of a notice is a criminal offence.
Right,
Your question is a good one, though, which is what happens if someone comes and asks you for data other than through this? Well, the answer is they should be coming through the right process, and no policeman should be coming to you directly, knocking on your director's door, asking for it.
See why we disclosed it, though.
Let me come on to that bit.
Yeah.
But the policeman should be coming through the right process. Forces have single points of contact for comms data. They should be coming through these well-trained individuals who know what they're asking for, who know what powers are available. It shouldn't be an average policeman.
So the individual police officer should be going to the single point
The
of contact.
expert within their force
Right,
for
so there's one in
communications
force,
data,
basically.
at least one in pretty much every force, going in,
Yes, that's right.
going through the right channel, and they will then advise the policeman to say, well, okay, if you need this data, here's what you need to do to acquire it.
Yeah, because in that circumstance, you could see why me saying, well, actually, go and get some official notice would be seen as me being difficult, possibly by the office.
Different operators have different rules on it. So some will say, no, if it's that urgent, you'll have no problem getting an authorization signed off to go and get it.
Yeah.
Equally, other operators will say, we will insist on a notice, on a proper authorized thing, except where there is a life at risk. And in that circumstance, they may be willing to take a sort of a more relaxed stance. Typically in that case, what I would generally say is, okay, fine, we'll look at it, but we're going to need some convincing, and we then expect you to go and get the notice afterwards so that the paperwork is completed for it.
So, presumably we can just actually, because we've never even looked into this, but presumably we can go to our police force and say, who is our single point of contact?
Yeah.
And there should be one person in the force, or
The trouble is it won't always be your local police force that comes to you. It depends
No,
which
of
force
course,
has got the investigation.
So if it's another force, it'll be the single point of contact from their force, or will they contact the single point of contact?
No, it's the force that's doing the investigation.
Yeah.
So it won't just be your local force for it. But if you've only had one ever, then I wouldn't be too concerned about it. If you're getting loads of them, then you have access to a tool which gives you a list of the single points of contact in each of the forces, so that you can validate that someone coming in is there. And there is a method of validation, and if you contact the College of Policing, they should be able to link you onto the tool. It's called Spockbook, for the single points of contact for that to validate the request. But okay, going off piece slightly, if you were to get someone coming and doing that, are you doing something wrong in disclosing the information to them? The thoughts that were going through my mind is, ultimately, which would I rather stand up and defend? That I gave the data to the police on a story that I thought was credible and seemed reasonable in the circumstances, or I didn't and someone died?
That's the dilemma. I've obviously done what I thought was...
In many circumstances, I would say, okay, I believe you. This is a sensible thing to be doing. I will get on and do it. If it turns out the policeman was acting on a frolic of his own and shouldn't have been asking, fine, we'll deal with that down the line. But get on and disclose the data. From a data protection point of view, the data protection principles don't apply where the disclosure of data is necessary to prevent the prevention or detection of crime. So
in terms of the actual thing that you were saying, disclosing the actual...
The existence of a notice or an authorisation...
So if I didn't notice, by me saying this and the fact this is recorded, I'd have been committing a criminal offence?
You have discussed about a situation which came up, rather than necessarily disclose the existence of a notice.
Right, fine.
We don't know yet how broadly this is going to be interpreted. We don't know whether it will be that much, or whether it would have to be disclosing more details. My feeling is it covers even the existence of a notice, so that may have been problematic. But it didn't happen, so it doesn't matter. Up to 2 years in prison and a fine for doing that. Now that's for disclosure without a reasonable excuse. We'll have to wait and see what reasonable excuses look like. Pretty clear that talking to a lawyer is a reasonable excuse. It's also pretty clear that going and publishing that you've had a notice, not a reasonable excuse. More granular than that, we'll have to wait and see. That's coming, 5th of February, so should start to see that coming at all. May affect some of you more than others, may not affect some of you at all. So, general conditions, the proper exciting bit. October 2018, so towards the tail end of last year, Ofcom changed its general conditions. Most of it was structural changes, but there were some changes of substance as well. Depending on who you serve, who your client base is, will depend on how much these affect you. General conditions are now split into 3 parts. The first one deals with network functioning, second part, numbering and technical bits, and the third part deals with consumers. Now, Ross is going to come and talk later about the changes to GCC 6, which deal with CLI. I do not have to do that. So what I'll talk through is I've cherry-picked some bits out that I think might be interesting or useful. It isn't, I'm afraid, an alternative to actually reading the darn things. But hopefully this will point you in the right direction in at least some of the areas. There is now, for the first time, a specific obligation in terms of emergency calling relating to outbound PSTN VoIP services. So if you provide a VoIP service that connects with the PSTN to allow an outbound call, there are specific obligations relating to that. The first, which actually a lot of people will have done for a while, is to have something very clear to customers on the website or in notices, and also in your contracts, that warn them that this isn't a hugely reliable service for calling the emergency services. If there's a power failure, if there's an internet outage, you will not be able to contact the emergency services. You also need to recommend that where customers use their outbound PSTN VoIP service from a fixed location, that they give you the location they're using it from, so that that can be passed through to the emergency services. They recommend also that where people use this service at different places, they give you an update every time they change location. Now, I have mine on a mobile phone, and I don't tell my provider every time I move somewhere. from that. So put it in your contracts, make people aware that the location information that the emergency services will get is only as good as the information that they're providing, but it still doesn't work well in that. Yes?
Can I just interrupt? So any working for pretenders, any 999 calls signalled through SimWood will be signalled as nomadic. So the address only exists in the instance that the call handler gets silence on the call, and they need to send an ambulance to somebody that isn't communicating. But it's very different to a fixed line call where it's signalled as a reliable address. So there is a slight there's a bit of leeway there should the address not be correct, because the call will be signalled as nomadic.
But obviously, when Ofcom actually get around to doing it properly, we can send them with SIP heads.
For now, you'll be incoming, watch out. What?
And Ring Central say that from their mobile apps you can't dial emergency services at all. What they do is they use the device, the mobile, to dial out from. So I guess, is that a reasonable thing to do, to say our service won't offer it on a mobile app? It forces you to use
I think it
the
was
native
hugely
dialer.
difficult to persuade Ofcom that you're offering an outbound VoIP service that connects to the PSTN and doesn't do 999 calling.
Well, that's definitely what Ring Central state, that they don't.
If it's inside the app, though, and if you're down 999 from within the app, and all it does is it then puts the call through the mobile signal, then it's allowing you to do so, isn't it? Well, then again, I suppose
I
if you were
think
on,
it's routing it very differently, and if you
were
were
on Wi-Fi and using that app, and you didn't have any mobile, I
Yeah.
suppose.
So I think that is sceptical, and I have seen Ofcom say before that no, it must be.
Yeah.
You must be able to call 999 or 112 through that service, not rely on them having a secondary phone or a SIM in the back pocket or something like that.
Okay.
Question down the front. Here. Throw it to me, and then I'll throw it onwards. There we go. One, two.
It was actually prompted. Sorry, it was prompted by the chap behind me, because I had a very similar question. Is there any situation that you can think of at all where an outbound service can state that it doesn't support emergency service calling? Full stop. Not in certain situations, use mobile app at all. I mean, it would save all of us a lot of time if there was, wouldn't it? But there's one that I know of. I'm not going to name.
Think of one other than potentially if you were to say the service only lets you call one particular number,
Right.
or something like that.
Yeah.
But if it's a general service for calling PSTN destinations,
Cool.
International call.
I thought
Yeah.
it was only residential that having to provide 999 for.
my feeling is you will struggle to say, you know, here's our app, but we don't provide 999.
You have to provide.
Oh, we do, but it's not necessarily
Yeah,
a
that's
problem.
my understanding. Is if you're providing a general PSTN termination,
My
you need to
understanding too.
provide
Yeah.
999, 112.
Obviously for all these years, but there was,
Yeah.
I read something the other day of providers' terms, which made me think, is there a loophole? Because they
There
seem
may
pretty
be
sure about
providers
it.
who are simply putting it in their terms
Yeah.
and saying that they don't do it. Doesn't necessarily mean it will stand up
Okay.
if
Yeah.
it came to Ofcom.
Yeah.
But if you don't do it, are you better off warning your customers? Interesting. You're kind of signalling to Ofcom that you're non-compliant, but at the same time, you're at least being truthful to people who may be relying on your services.
I don't think
Interesting.
anybody's been fined for not having it. People have been fined for it not working, because Vonage got a fine about 3 months ago for having a period where it wasn't working.
There were a couple of bits within that one for
Yes, there
999,
was,
weren't there?
And that's when I contacted them to say, us as providers under SimWood have no way of testing 999.
That's not civil specific.
No, obviously not. Yes, that's.
I mean, all you need to do is have an address.
Can we make
registered
sure
to-
you got the microphone before you speak?
As far as I understand, all you need to do is have an address registered to a user, whether or not it's an accurate address for their location at the time when they make a call.
Perhaps we split the two separate things. One is the passing of location data,
Yeah.
and the other is can they make a 999 or 112
Yeah,
call
yeah,
at all
yeah.
for doing that. And looking at it from a purely pragmatic point of view, the ability to make the call is more important than the address
Yeah.
information.
And that's
would be
mandatory.
Yeah.
Yeah,
Yeah.
for doing that. Sorry, I've put it right next to a speaker, haven't I? For that, okay, so moving on from emergency services. For those of you dealing with contracts with consumers and small businesses, so don't worry if you're selling into other areas, there are now more detailed requirements as to what you have to put into contracts. I've made the small print as large as I can. I still don't expect you to read it. It's GCC 1.2. Take a look, see what you've got to put in there. In particular, if you have bits that change within your contracts, variable pricing depending on usage, things like that, make sure it is all clear in your terms and conditions. If you sell a service for a fixed period, say 12 months, 18 months or whatever, and you then want it to renew automatically for a fixed period, you can now only do that where you have the subscriber's consent. So you can have the contract run on, sort of it runs on an ongoing basis once they come out of that initial fixed term. What you can't do is say you've automatically renewed for another 18 months unless you've got the subscriber's consent for that.
Define as run on though, is it? If you define as run on, is that 30 days or
12 months rolling,
general
quarter
condition is
rolling.
simply that you cannot renew it for another fixed period. So I would say you can carry on ad hoc on there. They still get to use the service. Whether that means you're then billing them on a month for it, but you can't say 12 months and it will then renew for another period of 12 months. I'd need to dig into whether that means you can say, but you're then on a monthly service after that. It's a good question. I don't have an answer for you off the top of my head. Charles.
Hang on, Charles.
That doesn't prohibit, presumably, the renewal of a fixed term, as long as it's just not automatic. That you can go back and renew a contract, can you?
Absolutely. You can go back and you can ask a customer to consent to automatic renewal, and they may want that to stop the service accidentally dropping or something like that at the end of the period. You can absolutely contact them
In advance.
and agree a renewal. What you can't do is automatically renew without their consent, basically to try and stop consumers being tied into ongoing long-term rolling contracts.
Yeah.
Felt that.
Price changes and material detriment, favourite topics. In-contract price changes, other than those linked to VAT, are now automatically material detriment.
What does that mean? Even RPI inflation.
Come on to what? Fall away. What this means is you must then give them the notice of their right to terminate. Okay? There are some bits and pieces within that that make life a little easier. If you have a contract that allows for different charges based on different circumstances, you need to spell that out. And then if one of those circumstances is triggered, that isn't material detriment. Let me go back. I also want to say that RPI-based increases are acceptable as well, as long as you don't go over the RPI.
Right.
So you can't base it on RPI.
So, yes. So you could increase the price by RPI,
By RPI,
and there
as long
wouldn't
as
be
it's clear in the contract
that you're going to
can
do that.
Yeah.
And if you and they wouldn't be able to terminate if you go to the top level of the RPI, but if you go above that, then they would have a right to terminate.
And I think you would struggle if you said RPI plus 3% or RPI plus something extra
Yeah. Okay.
for doing that. But I'll tell you what, for the questions that I remember, I'll put all the slides online anyway, and I'll try and pick out the questions and then put comments in to deal with those particular bits.
There's quite a good question here if you've got to.
I was trying not to. So are you saying that if we needed to change the charge on a cost to Dominican Republic, and it was one change on one route in our rate card, that we'd have to offer material detriment, or we'd have to offer the ability to exit the agreement because of that one change?
If you've sold a bundle that specifically includes calls to the Dominican Republic at that rate, then don't change the rate, or you need to offer the right to terminate. If you're selling a general calling package and here's your rate card for calls outside that bundle, i.e. they're entitled to make a call to it, but those don't form part of a call package, you can change those rates.
Fantastic.
So it will be more, you charge £10 a month and then call charges are on the rate card for this. You can't change it to £12 a month and do that, but you can change your next on rate cards.
So the way we work is we sell broadband and put the voice over IP as a free add-on basically to move the landline number across, and we update the rate card from Simwood and put our own percentage on the top of that for calls, and we do that update once a month, and we say that that's what we do in our terms, that we update the rate card once a month. Are you saying we shouldn't now be doing that?
I would think that's a similar principle to before, that your core contract is not changing. You're saying it's...
No, the broadband is still provided. The voice over IP is a free add-on to it.
It's still... The core
Yeah.
bundle is seemingly free,
Yeah.
but for out-of-bundle usage, which seems to be everything in your case, then it's the rate card is what applies to that.
Yeah, and the rate card is dynamic.
Recognising
Yeah.
that an operator isn't in control of their particularly
yeah.
extra geographic routing and their
Yeah,
costs
exactly.
for that.
Yeah,
Yes.
that's fine.
We've got another question at the back, Neil.
This may be getting too much into the weeds, but does this apply to price, if you decrease the prices, or is it just for price increases? As you say, price changes. If I decrease my price...
changes, I would need to read the general condition to be clear. I think it would be difficult for a consumer to argue that paying less was detrimental.
But I bet it would be an interesting legal question anyway.
It would be. I don't have the text of the GC in front of me. It's clearly designed to cover rises rather than that. But if anyone can come up with a situation where a consumer paying less would be a bad thing for them, I'd be interested. Then we can go with that. I suggest we keep moving because otherwise I'm standing even more between you and a bar. You must provide access to adequate billing information. Shouldn't be a particular problem. And you can charge a reasonable fee for providing a printed bill. So if you want to bill only online but someone asks for a printed bill, you can charge a reasonable fee for it.
£20.
Imminently reasonable, says a lawyer.
Do we have to provide one request a printed bill?
I would need to double check. I've only tried to pull out the bits that I think have changed, which is now you can charge a reasonable fee for providing a printed bill. There are restrictions on what you may show to subscribers in terms of call records relating to call and SMS. So you mustn't show calls 999 or 112, and you mustn't show calls that are free to caller in the national numbering plan. So having pulled bits and pieces out, these are the ones that I think are coming out as free to callers. So you've got some 080 and 0800, and then your 116s, your general services of sort of harmonised services of social value, I think they call them. So Childline and some of the other ones mustn't show to subscribers that those calls have been made to protect privacy for particular helplines.
Is that,
Sorry, I don't get.
Whoa.
we've got a question at the back here with the mic.
Who's got the cube?
Me.
Cube.
Okay. If you've got a call management and call reporting system,
Yeah.
Generally people have got information in there and call recordings. Are you saying that the free to call numbers now shouldn't be included in that call management package?
Let me see if I can find the general conditions, then we can look at it with the.
And if so, if
That
we
can't be right, surely, because if you might.
Let's see what's written.
or can
What
we
I said
minify
was-
the number so you can't see what number they've called, but you can see that a call was made?
Is that going to work? Excellent. Here we go. Cheers. So general conditions.
Did you want to get in that? Did you want to ask?
I was going to make a joke about his first two lines.
Oh, okay. So
The first line says accept, and the next line is that.
okay. So there's the condition.
Might have an argument, yeah.
Calls and SMS to emergency call numbers 999 and 112, numbers that are free to caller on the numbering plan, are not identified on itemised billing and any other records that you make available to the subscriber. If that is a record made available to the subscriber, that seems to be fall within it.
Strip it out.
Does that trump any MiFID requirements?
Any
MiFID 2 compliance?
curious? I don't know, but
I don't
Ofcom
think this
doesn't say
includes-
except for.
I don't think this includes free phone though. Not specifically, not 0800.
So it's any which are designated as free to caller in the national telephone numbering plan.
I'm going to argue against that though. That can't be right.
So as in that you don't think that that's what the general condition says, or that
if I
the numbers...
thought-
Sorry, I don't mean it quite like that. Or that the numbers in question aren't the ones that are free to call in the numbering plan.
We've got thousands of customers making calls. They're going to want to know when they're making calls to free phone numbers. I don't quite...
So first thing to check was, am I wrong in saying that that list of numbers are the numbers that are free to caller in the numbering plan?
Yeah.
I'm pretty confident that the ones I've pulled out are showing as free to caller, and then applying the rule, you must not show those to subscribers.
Can we minify the data so it's obscured so you can see there's still a call, but not the details of the number of dial?
Try it. It might not work. It may need a battery.
Okay.
The intention behind the condition is privacy.
Yes.
So it says identify.
So could you show there was a call, but not that it was a call to one of those? I suppose, yeah, it'll be interesting to see where Ofcom came to it. Part of me says, well, you are still identifying a call, and clearly any calls that have unidentified next to them are then a call to 999-112 or free to caller. But it doesn't say specifically which helpline they called. If you wanted to err on the side of safety, I would say no, you suppress the entire record.
Where you've got...
It might not be working.
Does this only apply to consumers, or is this for small companies as well?
This is all in the consumer section, so sorry, consumers and small businesses.
Right, because a small business may have people dialing out on their behalf, and they may record the calls because they're dialing out, and it could be that business calls an 0800 number,
Yeah.
and they want to have a record of that to see that this particular call centre agent called this number, and here's the recording.
Yeah.
And now, according to these
equally,
regulations, we can't
if they have
do
the
that.
records from their own phones, they will know what numbers were dialed. These are obligations imposed on communications providers.
Right,
So if they're
but-
recording on premise, equally, they will still have the...
But
the
most
details.
or I say most, a lot of communication providers now are providing hosted services rather than on-prem systems.
Yeah. In which case, I think that's looking sketchy.
I think there's probably the word emergency missing before or any other emergency numbers.
Childline.
Childline?
Emergency number though, but you wouldn't want that appearing on a phone bill, would you?
It said on the previous slide, any 0800 followed by 60.
Those are the numbers that I pulled out as the numbering plan. So if I would say there's probably a difference in terms of someone reading this and saying, I disagree with the interpretation, and someone saying, I think Ofcom's missed some key words out of it, because it did go through a lengthy consultation process.
Neil,
Yeah.
can I argue with you as well?
Yeah.
The possible, and I wouldn't know because I've not memorised the National Telephony Numbering Plan, obviously.
Well, don't ask the question.
I believe there's a distinction between free-to-caller and free phone services.
Yes, I agree. And when I went through the National Telephone Numbering Plan, it was specifically pull out those listed as
Right, so free-to-caller is 0800 plus
See whether
6.
I even
That's
have
fair
it on
enough.
there. No, I don't think I have it down
I've
there.
got another question over in the back. Any call with a retail price of 0.
Are you okay from having been hit there, and do you need a lawyer?
The National Numbering Plan defines free to caller as any call with a retail price of free, or could be dialed from a payphone without use of coins or cash.
So potentially
call.
really quite broad.
Very broad, yeah.
Thank you.
Less rubbish then.
So I think the conclusion we're drawing from that is we don't like that general condition. So if nothing else, something to go away and think about. Complaints handling, dispute resolution. Are you going to like this one then? So if you don't have one already, you need a complaints handling procedure. An internal document setting out how you handle complaints. There is guidance sitting below the general condition saying what that needs to include, as well as a customer-facing customer complaints code.
Are you needing this?
Okay. And where you include information in your bills at the moment about alternative dispute resolution, that's pretty limited. You now need to include more information about ADR. So not just who your ADR provider is, but how people can contact them, telling them that ADR is free to them, various other bits and pieces. Look in section 4, underneath the general condition. That tells you exactly what you need to do. I reckon I've got it down to about a paragraph, but it's quite a terse paragraph, and that needs to be included in all bills for consumers and small businesses. So, clearly, you have some questions about some of this. Where can you find some answers? On the Ofcom website, they've got a copy of the general conditions marked up, so you can see what changes have come through. They've got a transposition table, so that you can see what used to be 9.2 is now in C 1.2. And of course, they've got the general conditions as a consolidated text on there as well. So probably, given the changes, a good a time for a review, and by the sounds of it, a call with Ofcom. Lastly, European Electronic Communications Code. New directive that was passed towards the end of last year, comes into force December 2020. Sod knows how it will apply to us. However, when you think back to the 2002 framework, it was that gave us the Communications Act 2003. So I suspect if we do choose to incorporate it into our law, it will be something as big a rewrite or similar rewrite to the Comms Act 2003. Substantially new legislation. It introduces some new concepts. We now have number-independent and number-dependent interpersonal electronic communication services. So basically, for the first time, trying to capture over-the-top services that don't have PSTN interconnect. Including some computer games, it would seem, although debate is still split on that. So we've got... What are we looking for?
Oh, it's here.
Now don't throw that one. Okay. So at the moment, some changes. So we've got people who provide networks, people who provide PSTN interconnected services, people who provide non-PSTN interconnected services. I'm raising it simply to say this may be something coming soon. I don't know whether in a post-Brexit UK we would look to incorporate this or not, whether we'd stick with our own rules, whether we'd adopt some of them. But 2020 December is the transposition date for it. Maybe there'll be a consultation, but expect to see more obligations on what we call sort of an over-the-top service provider. If you're developing a new communication service, particularly if you're thinking about offering it into or through Europe, it will be worth taking a look and just seeing, can you meet the various obligations that apply? I'm dreading putting this slide up.
Well, I think actually you've probably had most of them, certainly from a
Brilliant.
time perspective. Although I
Done.
have one, because I haven't actually asked one yet.
Okay.
Give it. Good question. We must take it for batteries because you've not been talking too much. Lots of engagement there, Neil, which is encouraging. Are you available for hire, and how can people get hold of you?
That is a good question. Fortunately, information on there. People are very welcome to get in touch. I'm also on Twitter, and I generally tweet a variety of incomprehensible and uninteresting legal updates, but they cover this kind of thing. And if there's scope for an interesting public discussion about whether Ofcom's got the general conditions wrong, Twitter seems as good a place to have them. But otherwise, feel free, drop me a line, get in touch. We can talk about things, and I know some of you already do.